webinar 3 in the CDVA on-the-job training series. We're covering this time chapters 17 through 24. And we've picked out some topics for you that we will get into in a little bit of detail. And thank you, by the way, for being patient with the late start. My name is Katie Dwight. I'm a senior staff attorney at Swords to Plowshares, and I'm working today with Devin Bisman, an Equal Justice Works Fellow. And we have 7 topics for you today, and they include CHAMPVA, college fee waivers, which you haven't gotten to yet. That's in part of Phase 2 training. Specially adapted housing, debt waivers. As part of the Working with Veterans chapter, I'm going to talk more about military sexual trauma. I'm going to talk about fugitive felons, and finally we'll talk about veterans group life insurance. So at this point I am going to turn it over to Devin.
Okay. Show my screen. All right, first we're going to start with the CHAMPVA program, which is, click over, is the Civilian Health and Medical Program for the Department of Veterans Affairs. We're going to go over what's covered by CHAMPVA, eligibility for CHAMPVA, and issues which may arise with CHAMPVA applications. So starting off, what's covered by CHAMPVA: inpatient care, outpatient care, mental health, prescription medications, skilled nursing care, and durable medical equipment. There's a long list of things which are not covered by CHAMPVA, which you can find in this regulation here, 38 CFR 17272A. Notably, what's in that list of what's not covered is dental care. All right, so 2 big eligible parties for CHAMPVA, spouses and children of veterans. And they may become eligible in one of 4 ways relevant to the veteran status. 1, if the veteran has a 100% permanent and total disability for a service-connected condition. Secondly, if the veteran died from a service-connected disability. Third, if the veteran was rated 100% and totally and permanently disabled at death. And lastly, if the veteran died in the line of duty, not due to misconduct. Now, the first 3 here are fairly self-explanatory. I want to spend a minute with number 4. Now, if the veteran was killed in action, he would be eligible for TRICARE. Now, if you're eligible for TRICARE, you're not eligible for CHAMPVA. And it's a little bit distinguished from a line of duty death. Say, for example, if a veteran died at a stateside base here rather than overseas in Afghanistan or Iraq, for example. Okay, entitlement. What do you get under the CHAMPVA program? Generally, a person covered under CHAMPVA may seek treatment from any licensed healthcare provider or any licensed medical facility, including many VA facilities. How much is covered under the CHAMPVA program? CHAMPVA covers 75% of the cost unless the services are received directly from the VA, meaning the remaining 25% must be paid by the beneficiary. Okay. Moving on, you'll hear a lot of veterans are confused about the difference between CHAMPVA and TRICARE. What are the difference between the 2 programs? Am I eligible for both? I kind of lay out the eligibility here for TRICARE and CHAMPVA. Under TRICARE, you're eligible for TRICARE in one of 2 situations. 1, if you're a military retiree, and secondly, if you're killed in action. If you're eligible for the TRICARE program, you will always be eligible for TRICARE. You cannot choose between the TRICARE program and the CHAMPVA program. Now, under CHAMPVA, you obtain eligibility under one of the 4 ways we discussed in the previous slide. Spouses and newborns. So for spouses who were married after the age of 55, they retain their eligibility for the CHAMPVA program. Also, spouses who terminate a remarriage once again regain their eligibility. So therefore, really the only way for a spouse to lose her eligibility is to remarry prior to the age of 55 and to remain married during the second marriage. For new and expecting parents, it's important that new and expecting parents understand they have to complete these two eligibility criteria here prior to applying for the CHAMPVA program. So first they have to obtain a Social Security number for the newborn from the Social Security Administration, and secondly they have to establish dependency by contacting the local VA regional office. Moving on to eligibility for children. Children are eligible for CHAMPVA up to the age of 18 or up to the age of 23 if they're attending an approved school. Now that approved school can be virtually any post-secondary education. It doesn't necessarily have to be a California state school, as is a requirement of some benefits programs we're going to talk about here in a minute. Children may maintain eligibility after the age of 23 if they've been determined to be incapable of self-support. And notably, eligibility is not affected by the remarriage of the spouse. Okay, moving on, notification of eligibility. There are a couple different ways to be notified of eligibility. The most common way, a spouse or child may receive a VA Form 218765, which is a service-connected death award attachment, which this is the, I would say, the easiest way to obtain eligibility for the, most straightforward way to obtain eligibility for the CHAMPVA program. Now, for CHAMPVA, the VA makes three distinct determinations. I have the first two separated from the third one here because the first two you can appeal through the Board of Veterans Appeals or the CAVC. The third one here you have to appeal through the Health Administration Center. So first, the eligibility or the decisions which can be appealed through the BVA are whether an applicant is eligible for CHAMPVA and whether the services received are covered by a CHAMPVA beneficiary. And thirdly, what must be appealed through the Health Administration Center is the calculation of the benefit, meaning the percentage covered by the VA. If there's some dispute about what percentage of the benefit needs to be paid by the beneficiary and how much the VA will cover. So moving on for the administration of the CHAMPVA program. CHAMPVA processing is centralized to the VA Health Administration Center in Denver, Colorado. Now, to give you another acronym, it's known as the Chief Business Office Purchase Care, the CBOPC. I included the address here for reference and their hotline number. Other health insurance information. Now, if a CHAMPVA beneficiary has other health insurance information, it needs to be included first with the initial CHAMPVA application. Secondly, if your insurance information changes, you need to notify the CBOPC of any of those changes. Okay. Another common question people have about the CHAMPVA program, its interplay with Medicare and eligibility under the two programs and whether you have to have both. First, CHAMPVA is always a secondary payer to Medicare. So if a beneficiary is eligible for Medicare, you must have Part A and Part B to keep your benefits. So therefore, even if you're entitled to Part A Medicare, you must keep and pay for your Part B benefits. Most commonly, you'll run into this because after the age of 65, a beneficiary must be enrolled in Part A and Part B of Medicare to keep their CHAMPVA eligibility. And lastly, I just wanted to mention the interplay between CHAMPVA and the Affordable Care Act. As some of you may know, the Affordable Care Act requires all Americans to maintain a certain minimum level of health care coverage. It's just important to note that CHAMPVA meets the ACA standards. So if a beneficiary has CHAMPVA, they don't need to go online and apply for the Affordable Care Act or do anything else. They already meet the ACA standards by being a CHAMPVA beneficiary. Okay, switching gears a little bit, I'll move on to specially adapted housing. I want to start with this flyer the VA created, which helps provide a better understanding of the Specially Adapted Housing Program and also the Special Housing Adaptation Program. As you can see on the slide, there's a wide range of renovations which would qualify, and you can receive a grant to change almost any interior, exterior part of the home to help help conform to your disability. I don't recommend looking at the who is eligible part of this flyer. I think it's a little misleading, but I think what renovations qualify and the photo are helpful. So moving on to eligibility for specially adapted housing and special housing adaptation. You can find eligibility criteria in this regulation here, 38 CFR 3809. Now, it must be the result of a service-connected injury which occurred on active duty, was aggravated during active duty service, or you can also obtain an SAH or SHA grant if it's established under 38 USC 1151, what's commonly known as a 1151 claim. What's important to note here is you cannot obtain eligibility based on a combination of service-connected and non-service-connected injuries. It must be solely based on the service-connected injury. Okay, so moving on, second criteria for SAH eligibility in 3809B. Now, I don't really want you to read what's all on the slide here. There are really only two criteria. One, they must be totally and permanently disabled, and to break down which one of these 6 categories they fit into and whether or not they're eligible, just to make it clear, if a veteran is able to walk into your office under his own power, chances are they're not eligible for an SAH grant. As you'll see, as I've highlighted on red on this slide, it must generally be something which precludes locomotion for them to be eligible for this grant. Under number 2, that's not true, but again, you'd have to be blind in both eyes and lost the use of one of your lower extremities. There is a new regulation which came out last year which this applies only, I don't have a slide on this, but it only applies for only post 9/11 veterans. The disability does not have to be totally and permanently disabling, but the disability must still preclude locomotion. So again, they wouldn't necessarily have to fit into one of these 6 categories, but they would have to meet this requirement here, which I took out of the M21-1MR. And preclude locomotion means the necessity for regular constant use of a wheelchair, braces, crutches, or canes as a normal mode of locomotion, although occasional locomotion by other means may be possible. So again, if a veteran is able to walk into your office under his own power, probably not eligible for an SAH grant. Okay. Now for special housing adaptation, similar to SAH but slightly different, applies in one of 2 situations. First, if a veteran has blindness in both eyes with a 5/200 visual acuity or less, or anatomical loss of both hands below the elbow. If it's above the elbow, they'd be eligible for SAH, below the elbow, SHA. If you understand SHA, these 2 criteria helps make the other one much easier. Again, you can imagine a veteran who fits into one of these 2 categories who would still be able to walk into your office under his own power, but still have significant handicaps where he would need assistance in the home with certain tasks. Okay, let's get into the maximum awards under the SAH or SHA. For SAH, the maximum award is $70,000, $465. That's the 2014 adjusted number. It may have changed. Now, you may not use more than 3 awards during his or her lifetime, but it's important to know that you can be awarded at least 3 awards. Maximum award for SHA is $14,093. Also important to note is homes owned by family members are also eligible for these grants. However, they're not eligible for the full amount. Under SAH, you would get $30,934. SHA, $5,523 if it's not owned by the veteran or the applicant, I should say. Okay. Just something else to note, I would recommend I would recommend a veteran applying for either SAH or SHA and receiving an award prior to spending these amounts. In some cases, a veteran may be able to recoup these amounts, which I'll get to here in a minute, but let's get into it here. But I would still recommend that a veteran may obtain an award prior to spending the money to make the changes to the home. So under specially adapted housing, can be used in one of three instances: to build a new home, remodel an existing home, or you can apply the grant to the unpaid principal mortgage balance of a home which you've already adapted. SHA, a little more limited, only adapt an existing home or adapt a home to the veteran or the veteran's family member which they intend to purchase. Okay. I want to touch briefly on SAH eligibility under 38 U.S.C. 1151. Now some of you may be aware a veteran may become totally disabled due to VA care rather than an in-service injury. It's commonly referred to as an 1151 claim, most commonly caused by VA medical malpractice, but it can be in other circumstances as well. Now, if a veteran brought an 1151 claim, he can also bring a claim in court under what's called the Federal Tort Claims Act. Now, if a veteran brought a claim under the Federal Tort Claims Act and was awarded a tort judgment or a settlement, that number must be offset against the SAH eligibility. So I just listed a couple questions here if it's an 1151 case that you would want to ask the veteran. Did you sue the government because of your injuries, or did you or an attorney have to go to court, or did you only file through the regional office? Because if they obtained a judgment in court, that number would have to be reduced from their SAH eligibility. And the veteran should know whether or not they filed a claim against the government. How to apply for SAH or SHA. This is a nice one-page form, actually, VA form 264555, which is the application for acquiring a specially adapted housing or special home adaptation grant. You can get your local VSO, e-benefits, or the regional office. Okay. It's administered by the VA Regional Loan Center. Now, for California, that's the Regional Loan Center, which is located in Phoenix, Arizona, which I provided the address here. Got their customer service hotline number, which may be a little bit different than what you're used to. When calling this customer service line, it doesn't operate like the VSO hotline or other benefits lines where you just wait on hold and a representative eventually picks up. There's a list of options which you have to choose from. If you don't choose one of the options, it'll just hang up on you, which can be frustrating. So to get assistance with SAH, you want to press 5 for assistance. And then also have the email address here to get further SAH info. Another thing you need in addition to initial eligibility, you need determination of medical feasibility. Now this is a determination made not by a VA rater, but a medical determination by a VA physician. It's a determination of whether or not the veteran, based on his or her disabilities, can reside in the home that is adapted to the SAH standard. So in order to receive this grant, you must have the certificate of medical feasibility, which is again why I would recommend a veteran going through this process prior to spending the money, assuming they're going to be granted the SAH or the SHA loan. Okay, moving on to our third topic, California college fee waivers. Now I'm going to discuss the 4 separate plans and eligibility for 4 separate plans for California college fee waivers. Okay, first, benefits of the program. It waives all mandatory system-wide tuition and fees at any state California community college or California State University. Now the important thing here, it does not apply to private institutions. This is only California community colleges and California state universities. The 4 eligibility plans, known as plans A, B, C, and D, and they apply to dependents of veterans rather than the veterans themselves. Or I'm sorry, Plan A applies to veterans. Plan A and B apply to dependents of veterans. C and D, the veterans themselves can apply for. Moving on to Plan A. Plan A has two requirements. You have to have wartime service and totally and permanently disabled due to service-connected disability or whose death was service-connected. It applies to children between the ages of 14 and 27 and up to the age of 30 if the child themselves are a veteran. Spouses are also eligible, and unmarried spouses if the death was service-connected. Now note at the bottom, there cannot obtain Chapter 35 benefits and Plan A. Now I know you haven't learned about this yet, but Chapter 35 is a federal program which is very similar to the California Plan A program, which pays for tuition and fees, books and supplies. My thought would be if a veteran is eligible, I'd probably want to apply under Plan A and Chapter 33 rather than just having Chapter 35, but again it would depend on the veteran or the dependent's overall eligibility. Moving on to Plan B. Now, most of the time when we're doing a case involving a California college fee waivers, it's going to be a Plan B case. There's three eligibility criteria. A child of a veteran. You have to be a child of a veteran. The veteran must have a service-connected disability whose death was service-connected, and the child's annual income does not exceed the annual income limit. Now, you can imagine this doesn't have to be totally and permanently disabling. This can be any service-connected disability, which of course opens us up to a much broader range of veterans. So I'm going to spend some time actually with number 3, the annual income limit, which there are a lot of requirements on procedurally and supporting documentation you need to prove for this third requirement here. So for the annual income limit includes both the income of the child and the value of support provided by the parent. Now, the income limit cannot exceed the national poverty level as determined by the U.S. Census Bureau. Now, in 2014, for a one-person household, that number was $12,316, so it's less than $1,000 a month for a single veteran, or a single child of a veteran, I'm sorry. Also to note, if the child receives no support from their parent, they must also include an explanation with the application as to why they don't receive any support from their parent. Okay. In addition, they have to verify their income. So a child under Plan B must submit a federal income tax form 1040 or a state income tax form 540 or a statement from the IRS or federal tax board which verifies their income or that they did not file a tax return. I guess the important thing to note here is there's no self-certification for this program. It must have income verification from either the federal or state government. Just wanted to do a quick example of a Plan B case here. Say someone comes to your office this year on June 8, 2015 and wants to apply to start school on August 5, 2015. Which tax form would be required and what is the maximum he or she could earn? You would need their income tax form from 2014, for example, their 2014 1040 or 540, and you would use the national poverty level published by the Census Bureau on December 31st, 2014. That's just an application there of the annual income limit. Okay, so just one more time, a recap of all the requirements under a Plan B case. First, you need a California college fee waiver program for veterans dependents. Secondly, you need a veteran, of course, with a service-connected disability. Thirdly, you need residency in the state of California as determined by the institution. Now, some institutions may be a little bit different, but generally this requires physical presence, intent to become a California resident, and physical independence. So for intent to become a California resident, it often helps if the child of a veteran has a California driver's license, shows an intent to remain in the state of California. Financial independence, you'd want to show that a parent living in another state did not claim this child as a dependent. Fourth requirement here, annual income below the national poverty level. Fifth requirement, tax form verification of that income. Sixth, they need a verification of dependency to the veteran, which you need some government documentation here. Generally, it's going to be a birth certificate, adoption records, or other government documents. And lastly, not to forget, they need to attend a California college or university. It cannot be a private institution. Okay, I'm going to touch briefly on Plan C eligibility. Now, Plan C is any dependent of any member of the California National Guard who in the line of duty while in active service to the state who was killed, died of a disability resulting from an event that occurred while in active service to the state, or is permanently disabled as a result of an event that occurred while in the service to the state. This is available for child or surviving spouses. Important to note, it must be pursuant to Section 146 of the California Military and Veterans Code. Essentially what that means is that it has to be, if you want to look into the statute for further clarity, but generally means they were called by the president to service, not simply called by the governor. For example, if you were called to work on a California forest fire solely by the governor, you wouldn't be eligible under this plan. But if you were called to work at Hurricane Katrina by the federal government as a National Guardsman, that would be under Section 146. I'm not going to cover Plan D because it's limited to Medal of Honor recipients and children of Medal of Honor recipients, which is a fairly limited class of individuals. Finally, I'm going to cover one more program here, the California National Guard Education Assistance Award Program, or CNGEAPP. You get the same benefits under this program as tuition and fee waivers under the 4 plans. 2 requirements here. You must be an active Guard or reservist with at least 2 years of service, and you must agree to remain active throughout the program. This program is probably best for veterans obviously with at least 2 years of active service and who haven't yet deployed and have limited post 9/11 GI Bill benefits or Chapter 30 GI Bill benefits. This may help to cover costs not paid for by Chapter 1606 or Chapter 1606 benefits, which are only several $100s a month rather than covering the full cost of tuition. Lastly is just kind of a summary slide of my own plea here. Encourage veterans to attend California colleges. The average in-state tuition at a junior college in California this year was $4,945 for the 2013-2014 academic year. Conversely, for private institutions, it was $28,309. So you're looking at $16,000 every 6 months. I'm sorry, $14,000 every 6 months as compared to $2,000 every 6 months. There's just a substantial change between the 2 programs. So if a veteran is eligible under Plan B or one of the other Plan Bs, I would strongly encourage them to attend a California college. And also you might hear from veterans that, well, my program's only offered at private institutions. I would encourage them to look into that to see if that is actually true, that their program is not offered by a local community college or a local state university, because my guess is 9 times out of 10 the similar program would be covered at the California institution. Moving on to my 4th topic here, it's going to be debt waivers. I'm going to cover what to put in a debt waiver application and when a debt waiver will likely be granted. First thing I want to mention here is that a debt waiver is not a dispute of the debt. A request for a waiver is more of an acknowledgement that an overpayment has occurred and the debtor should not have to repay the debt because of the debtor's circumstances. So this is more indicating that, yes, I, the veteran or the beneficiary, made a mistake, but due to my circumstances, I should not have to repay it. I have on the bottom of the slide here 38 CFR 1.911C3, where the debtor may actually appeal the decision, which you can do through the local regional office or the pension management center, or if it's applicable, the debt management center, to appeal the decision of the underlying debt if the debt determination is incorrect, rather than requesting a waiver due to the beneficiary's circumstances. Moving to debt waiver requirements here, you need a written letter explaining why the debtor is requesting a waiver. Now in that letter, there's not a VA form for this. So it's something that the beneficiary or the CVSO has to create on their own. And you're going to want to argue the statute. You're going to want to know 38 CFR 1.965A. There are a list of 6 factors which we're going to go through. So one, you need the letter. Secondly, they will not consider a debt waiver request without VA form 5655, which is a financial status report. So those are the 2 requirements for requesting a debt waiver. There's 6 deadlines or I guess things that can occur in the debt waiver process. First, you're going to get the beneficiary will get a proposal of adverse action notice. They also normally say something to the effect of, you've been overpaid, we're going to start to reduce your benefit or refer your debt to the debt management center if you don't pay us back. Important to note, this notice generally doesn't include an amount. Now from this initial notice, you have 30 days to respond to what's called stay the withholding. Now if you respond within this 30-day period, the payments you've been receiving in the past will continue during your dispute process. Now again, you should only do this if you believe the proposed action is incorrect. As if the proposed action is valid, you're just going to end up with a larger overpayment if you respond within the 30 days. Number 3 here is the second, or the what I have in red here is 60 days after the proposed action, the VA will send a notice. Now this notice includes the total amount owed. Now this is the official start marker to when it's been referred to the debt management center and when you owe a debt. Now you know this is the actual notice rather than the proposed notice because this notice includes the amount, say John Smith owes $6,500. The proposed adverse action notice will not include an actual amount owed by the beneficiary. Now in number 4 here, you have 180 days to request a waiver from first receiving this notice, which included the amount. And you have 1 year from receiving the notice listed in number 3 to appeal the decision. Not to appeal the waiver, but to appeal the decision that I shouldn't owe them, that the beneficiary shouldn't have owed the funds, or shouldn't have to pay back the amount. Okay. Moving on, what to include in a debt waiver letter. Listed here first, be an advocate. Now this isn't a hard and fast standard. You'll see here, waiver will be granted if there's a showing that collection of the debt would be against equity and good conscience. And again, make sure to include VA Form 5655. So we're going to get into the 6 factors now in which you can argue a debt waiver. I included 1 and 2 together here, whether the debtor was entirely at fault in creation of the overpayment, or was there also fault on the part of the VA. Now this is good to argue when the debtor notified the VA about the change in circumstances or other information relevant to the overpayment. For example, if you're working on a pension case where the veteran notified the VA on February 1st that, hey, I'm going to be going back to work, stop paying me my pension, and then they continued paying pension for 6 months, you'd want to make an A1 or an A2 argument. Something that you can't argue under these factors, and the VA is not responsive to, is ignorance of the law. Essentially, I didn't know that I had to report my income if I earned income other than my VA pension. So that's not gonna get you anywhere with the debt waiver argument. Moving on to A3, undue hardship. Now this is the most common and most probable way, I'd say, of getting a debt waiver. Whether the collection of the debt would deprive the debtor of family or basic necessities. Now what we like to do is use VA Form 5655 information to make the argument. See, for example, in box 24A, if that number is 0 or negative, now I should say that box is the total net income minus expenses. So if the veteran has, or the beneficiary has more money going out every month than they have coming in, clearly they're not going to be able to pay this debt. So therefore, if payment is withheld, the debtor would not be able to afford food, shelter, medical care, transportation, or basic utilities such as electricity or gas. So again, this is the strong argument to make if the veteran's got more money coming out than he has coming in. Kind of along those same lines as the A4 argument, does it defeat the purpose? This is whether withholding of the benefits or recovery would nullify the objective for which benefits were intended. This is most commonly if someone has a debt in a pension case. I normally state the standard for the benefit. Pension is a tax-free monetary benefit payable to low-income wartime veterans. And you'd want to explain that withholding of the benefit would be against equity and good conscience because withholding of the pension payments would result in homelessness or starvation, which is exactly what the pension program is designed to prevent. Okay, moving on to A5, failure to make restitution would result in unfair gain to the debtor. This is kind of a VA rebuttal argument. So something you can get around this, was the veteran able to save any of the overpayments, or were the payments used for basic necessities? And if the veteran wasn't saving any money every month and these were going to pay for basic necessities, I would argue that the veteran has not been unjustly enriched by the overpayments. I'm not going to discuss A6 because it's usually only applicable to home loan situations in rare cases. Okay. It's important to know about waiver preclusion. Under the regulation, waiver is precluded if fraud or misrepresentation or the debtor lacked good faith. Generally, I like to include a statement that the veteran did not know that he or she had to report the income or that he made no effort to hide the information from the VA. So again, ignorance of the law wouldn't be a good argument for receiving a waiver, but it would be a good argument to show that the veteran didn't lack good faith. He didn't know that he couldn't receive payments from, say, for example, the Social Security Administration and the VA at the same time. He was just unaware and didn't try to do anything to hide that information from the VA. Okay. I want to mention waiver hearing. You request a hearing at any time in the waiver process. It's important to know generally it's a slower process for a waiver request than requesting without a hearing. Hearing might be generally good for a sympathetic client who may not have the best case on paper, or if you just want to make sure 100% of the time that the VA gets it right, I would recommend requesting a waiver hearing, even though it might extend the process. Okay. And lastly, I want to discuss briefly disputing the validity of the debt. Now, this is under 38 CFR 911C3. If the debtor disputes the debt itself, the VA must first decide the validity of the debt before making a determination as to the waiver. So you're free to, and we generally do, we dispute the debt and request a waiver at the same time. Most commonly when you want to dispute the debt, we'd see the best debt dispute cases are when the VA has spotty records of their work history and believes the veteran earned more wages than they did, or incarcerated veterans where the VA hasn't properly calculated the periods of incarceration are very good cases to dispute the validity of the debt as well as request a waiver. I want to touch briefly on VA administrative error. I don't want to get into all the standards for administrative error, but what you need to know is the veteran can keep the overpayment if based solely on administrative error. Something to note is that VA delay is not considered administrative error. Common scenario we run into, veteran notifies the VA on February 1st that he's going back to work on March 1st. On March 1st he goes back to work, begins earning wages. His pension payments don't stop on March 1st. They continue on for 6 months, and then he spends those 6 months of pension payments. Now, that would still result in an overpayment even though he notified the VA. So it's important for the veteran to not spend those overpayments, and the VA delay by itself would not be VA administrative error. I also want to touch on something we've had success with here is there's no deadline for submitting what's called an EVR, which is an eligibility verification request for VA pension. This is kind of a little-known rule here in the M21-1MR. And the VA example, actually, in the M21 includes a submission of an EVR for income earned more than 3 years prior. So say, for example, if you had a veteran who earned $10,000 a year over a 2-year period, the VA thinks they earn $35,000 a year, and therefore they greatly reduce their benefits under the pension program, or probably eliminated all of them, when in fact they had some level of entitlement. Even 5 or 10 years later, you could go back and submit that proper income information and the VA would be obligated to recalculate the debt based on the new EVR information. Lastly here, I want to discuss VA compromise. Now, there's no time limit for requesting a compromise of the debt. Generally, we like to request waivers and to dispute the validity of the debt prior to making a compromise offer, but again, this is a case-by-case basis. Now, you're going to want to use VA Form 5655 in box 24B, which is essentially where you make your compromise. So you're going to look at what your net monthly income is in box 24A and what can be paid towards that debt. So for example, if your net monthly income minus expenses in box 24A was $200, we might say, hey, the debtor can compromise and pay $50 a month out of that $200 towards his VA debt. Okay, so that is the conclusion of part 1. I'm going to turn it over to Katie Dwight to discuss the next 3 topics.
Okay. Thanks, Devin. The first thing I will be discussing is military sexual trauma. And this is part of, it goes along with chapter, I don't remember the number, but the Working with Veterans chapter, where we try to get you all to think about, be thoughtful about what it will be like for you to work with veterans from all different backgrounds and what challenges that might present or what rewards that might present. And I guarantee you are going to be seeing more and more veterans, both men and women, who have been victims of military sexual trauma. I think that we're just seeing the tip of the iceberg right now with these claims, and there's going to be more and more current era veterans and also some from decades ago that have just learned that they might be eligible for benefits based on this. So military sexual trauma is defined by the VA as psychological trauma which in the judgment of the mental health professional employed by the department resulted from a physical assault of a sexual nature, battery of a sexual nature, or sexual harassment. Sexual harassment consists of repeated, unsolicited, verbal, or physical contact of a sexual nature which is threatening in character. Some recent studies have shown that sexual assault in the military context can be particularly traumatizing above and beyond the effects in civilian populations. And that's for a number of reasons. Unlike civilians, service members must live and work alongside their assailants, and that can aggravate the traumatic effects of the assault. The vast majority of perpetrators are fellow service members, whether coworkers, supervisors, or higher-ranking officers. The military emphasizes unit cohesion and being a team player, and that can lead someone to, instead of seeking treatment, to feel that they just have to suck it up. Also, they're not likely not to have as many resources as a civilian would to help them with readjustment. So for these reasons, military sexual trauma can result in more severe PTSD in the military than out. So from 2008 to 2012, 39.2% of MST PTSD claims were approved, compared to 61.8% of all other PTSD claims. For every year between 2008 and 2011, a gap of nearly 10 percentage points separated the overall grant rate for PTSD claims brought by women and those brought by men. So other PTSD claims are being granted at a much higher rate than military sexual trauma claims. And because of that, that skews the numbers so that a lower percentage of women are granted PTSD for whatever reason than men are. There's a lot of variety between regional offices and the percentage that they grant these claims. St. Paul, Detroit, and St. Louis regional offices have the worst grant rates for MST-related PTSD claims. In 2011, Los Angeles RO had one of the highest grant rates in the country. Because of the big difference, geographic difference that separates claims in different offices and the likelihood of success, an organization called Service Women's Action Network, or SWAN, made an effort to try to get the VA to change the regulation for MST, for proving MST. They filed a petition for rulemaking proposing this alternative language. Military sexual trauma. If a stressor claimed by a veteran is related to the veteran's reported experience of military sexual trauma, and a psychiatrist or psychologist confirms that the claimed stressor is adequate to support a diagnosis of a mental health condition, and that the veteran's symptoms are related to the claimed stressor, in the absence of clear and convincing evidence to the contrary, the veteran's lay testimony alone may establish the occurrence of the claimed in-service stressor. So this should look pretty familiar. It's the language that appears in the regulation on PTSD resulting from fear of hostile forces. So SWAN was advocating that this be established as the rule for MST. One of the reasons they say this is that it's pretty rare that there are actually records in service treatment records or any in personnel records of reported assaults. The Department of Defense estimates that in fiscal year 2012, 89% of service members who experienced sexual assault did not report it to an official. One reason for that is the lack of confidentiality. Service members with MST have two choices if they're going to report at all. One is a restricted report where no investigation is done at all, but their personal information is kept private, or the unrestricted report, which starts an investigation, but everybody you know in the military will know that you reported it. Another reason for not reporting is that not only do survivors know their assailants, they are frequently subordinate to them. About a quarter of survivors of sexual assault in the military identified their attackers as being within their chain of command. And 38% of women and 17% of men reported that their assailant was of a higher rank, though not in their chain of command. Another problem with the current rule, VA adjudicators expect veterans' work performance and personal life to suffer after their assault immediately. That's sort of written into the regulations that you look for changes in behavior. But, you know, that's not always the case. Sometimes a person may redouble their efforts at work after an assault rather than, you know, their performance going down. And so this regulation would provide an alternative means to prove MST. SWAN argued when they were making this petition that that all veterans submitting a PTSD claim must prove the occurrence of the claim stressor causing the PTSD. However, VA applies liberalized standards for proving the occurrence of the claim stressor in 5 circumstances: when the PTSD is diagnosed while the veteran is in service, when PTSD is incurred as a result of combat experience, when PTSD is incurred as a result of prisoner of war experience, and when PTSD results from fear of hostile military or terrorist activity, and when PTSD results from personal assault. VA applies its most liberal standard to PTSD claims related to combat and prisoner of war experiences. For these claims, if the veteran has been diagnosed with PTSD, the veteran's lay testimony alone may establish the occurrence of the stressor. That is not the case for military sexual trauma cases at this point in time, and that is what the organization SWAN is seeking to establish. When they submitted their petition for rulemaking, SWAN was forced to seek judicial mandate because the VA didn't respond to it. They were able to get a court order, and the VA denied the petition with little explanation. SWAN filed a petition in the Federal Circuit Court, SWAN v. Gibson, stating that the denial of the petition for rulemaking was arbitrary and capricious and abuse of discretion in violation of the Administrative Procedures Act. SWAN also argued that denial was a violation of equal protection under the U.S. Constitution, stating that the current policy detrimentally impacts women more than men. That case is currently pending. There's been no resolution as of yet. This case, AZ v. Shinseki, is, I thought, an interesting case. It was an appeal up to the Federal Circuit from CAVC, and there were actually 2 cases that were consolidated. And the issues were, does the absence of contemporaneous mention in military service records of MST serve as pertinent evidence against the existence of sexual assault? Does the absence of a report to military authorities serve as evidence against the existence of sexual assault? In this case, the woman had been assaulted and had not reported it. It did not appear in her records, but she did have some other indicators of MST, and she was able to get family members to report that, to write letters stating that she had told them about the assault at the time. The VA said, well, we don't believe you because there's no record in the military records, and we're going to hold that against you. So what the BVA said is, you may not use the absence of records or a report to military authorities as affirmative proof that the assault did not occur. So I'm sure you know that typical symptoms among MST survivors, to name just a few, are intense emotions, including depression and anger, trouble sleeping, difficulties with attention, concentration, and memory, problems with alcohol or other drugs, re-experiencing the trauma or going out of their way to avoid any reminder of the trauma, difficulties in relationships such as sexual difficulties, chronic pain, weight or eating problems, or gastrointestinal problems, and feelings of shame. We found that we have to be extremely sensitive to the needs of these veterans, both men and women. They both experience these symptoms. Men seem to have particular issues around shame, feeling that they weren't man enough to stop the assault, and issues of that nature. So being sensitive, not making assumptions, and just listening will help them open up about the situation. If you don't listen and give them a chance to talk, they're not gonna bring it up. It's just going to be too painful for them. So at your phase 2 training, you're going to be talking about interviewing skills and advocacy and that type of thing, and so you'll get to talk more about that then. So I'm going to move on to the fugitive felon policy. In 2001, Congress added a provision to the federal veterans laws which allowed for the suspension of benefits during periods in which a veteran who has committed a felony is fleeing to avoid prosecution. The reasoning behind this was that it was illogical for the federal government to be supporting a felon while they were on the run, in effect financing the felon's escape. But the way there were different ways the VA could have interpreted this statute. But the way that they ended up applying it was that they would treat any veteran as a fugitive felon if he or she had a felony arrest warrant out for them. Also, anyone with a probation or parole violation. So it's a pretty expansive interpretation of the law. The Social Security Administration had the exact same law, and they got sued in a class action for this interpretation. The Social Security Administration's fugitive felon law was enacted in 1996, 5 years prior to the VA statute. The Social Security Administration was sued by class action, and a settlement was agreed upon where the Social Security Administration would no longer assume that every veteran with a felony warrant was a fugitive. The VA took note of this ruling, and but they did not decide to change their policy. But they did start communicating with some veterans advocates about the issue related to, and agreed to change their policy finally last year in 2014. So their new policy is that they will request the information only for, they will basically investigate beneficiaries who have a felony arrest warrant only when the National Crime Information Center offense code indicates flight or probation or parole violation. The National Crime Information Center is a federal agency, and they assign numbers to all different kinds of offenses. And they have a number, 4901 is their number for what they call escape. So that's a crime involving escaping. 4902 is flight to avoid prosecution. So basically, they're going to look at specific numbers and only take action if numbers indicating flight or parole violation or probation violation are indicated. VBA will discontinue benefits based on fugitive felon status only if a judge issued a felony arrest warrant with an NCIC offense code indicating flight or a probation or parole violation. VA provided the beneficiary notice regarding the reason for the warrant and an opportunity to present evidence, such as the acknowledgement of the validity of the warrant or failure to respond to the due process notification, or that he or she did not flee from justice or did not violate any condition of probation or parole. And if the VA determines, based on the warrant and evidence submitted by the beneficiary, that the beneficiary was fleeing from justice or a probation or parole, only in this situation will benefits be terminated. The VA had been had a system in which they would get information from the National Information Crime Center, and that there was a felony warrant of any kind, or it didn't even have to be a felony. They would get information that there was a warrant out on a veteran, and they would start the due process process. And even if it was it could have been a misdemeanor warrant, which would not qualify for the fugitive felon, would not fall under that. But they would put the onus on the veteran to prove to the VA that it was a warrant that did not qualify. And sometimes this could be quite difficult to prove. So now they will not presume any longer that the veteran's warrant is the kind of warrant that would stop benefits. They will not apply the presumption of flight, but they will maintain payments in discontinued status only if evidence establishes that the beneficiary is fleeing to avoid prosecution, custody, or confinement, or is violating a condition of parole or for a felony. So a lot of people don't know that there's a new policy, that this is the new policy. So I wanted to have a chance to cover that. Next, I'm going to talk about veterans group life insurance. So veterans group life insurance, first of all, it begins with service members group life insurance. SGLI is a program that provides low-cost term life insurance coverage to eligible service members. If eligible, you are automatically issued the maximum SGLI coverage. If the service member qualifies for SGLI, he or she is automatically enrolled and they do not need to apply for coverage. Service members can make changes to SGLI coverage, or they can decline the coverage, or select a lesser amount, change beneficiaries, and or make other changes. The eligibility for SGLI is that you are active duty member of the Army, Navy, Air Force, Marines, or Coast Guard, commissioned member of the National Oceanic and Atmospheric Administration or the U.S. Public Health Service, cadet or midshipman of the U.S. military academies, member, cadet, or midshipman of the Reserve ROTC engaged in authorized training and practice cruises, members of the Ready Reserve or National Guard, and scheduled to perform at least 12 periods of inactive training per year, service member who volunteers for a mobilization category in the IRR. The SGLI, the maximum coverage is $400,000. They receive 240 days of free coverage from the date of separation. And during that period of time is when the veteran needs to sign up for or switch their coverage from SGLI to VGLI. The eligibility is the same for both. You will not be eligible if you are terminated for those who are terminated are guilty of mutiny, treason, spying, desertion, or conscientious objection. And no claim is payable due to death by capital punishment. So there's a 240-day period, and the SGLI will end on the 241st day after discharge from service. However, when a veteran has a total disability, they can get an extension up to 2 years. if they can prove that they're totally disabled, then they will not have the 240-day deadline, but will have a 2-year deadline. The definition of total disability is defined as an impairment of mind or body which continuously renders it impossible for the insured to follow any substantially gainful occupation. The permanent loss or loss of use of both feet, both hands, both eyes, etc. The total loss of hearing, the organic loss of speech, which means the physiological loss of the ability to express oneself through the normal organs of speech. The veteran need not be rated totally disabled by the VA to be considered totally disabled for this purpose. The effective date is, as I mentioned, the 241st day after separation. And that's a change actually from earlier. The deadline was 120 days, but that switched in November of 2012. They lengthened that period to 240. For the totally disabled veteran, on the date of if the member is totally disabled on the date of separation or the day following the date that total disability ends, but in no event will VGLI become effective prior to the 241st day after separation. An acceptable application and initial premium must be received in the Office of Service Members Group Life Insurance. OSGLI implements the life insurance with the VA's guidance. Premium payments can be made directly to the OSGLI by direct remittance or by allotment from military retirement pay or as a deduction from VA disability benefits. A veteran may pay VGLI premiums in advance, and veterans who pay less frequently than once a month receive a discount. The rules regarding beneficiary designation are the same for SGLI and VGLI. The veteran can appoint more than one beneficiary. They can split up the award, give a fraction of the award to different beneficiaries. They cannot appoint any beneficiary, in which case the award will be given out in accordance with law. The accelerated benefit option is available to terminally ill veterans under the VGLI program, and they may receive up to 50% of the value of their insurance coverage if they have a doctor's note saying they have 9 months or less to live. Termination will occur, as I mentioned, if they don't sign up for VGLI after SGLI expires, and it will also terminate the 31st day of AWOL, confinement for court-martial or confinement by civilian court authority, or the last day of the month following a request to terminate coverage. And that's all we have for the presentation, but I would definitely like to hear any questions that you might have. Also, I want to apologize again for the delay in getting started. We had some technical difficulties over here on our end, so that's why we got late. But please let me know if you have any questions. Are you seeing any questions, Rob?
There's no questions. There's only one comment, and that is establishing eligibility for a dependent is now taking 18 months. That's a long time to go without CHAMPVA coverage. Do you want to respond to that?
Yes. No, I wholeheartedly agree with that. Any questions? The fourth webinar, we're going to be going over the last quarter of the manual, which is on interviewing skills and advocacy skills. And so for the next webinar, we're going to be covering those skills rather than covering topics. The only one topic we will cover, you will cover at the phase 2 is the the California CDVA benefits. But other than that, it's going to just be advocacy. So if there's no other questions, we'll just call it a day. Is there nothing else?
No,
Okay, let's
just a few comments.
call it a day,
But
and thanks so much for listening. Oh.